Hello, everyone. Welcome to this edition to the Friday Law Talk. Before we begin, I want to give you the disclaimer. This is a live presentation that is intended to provide legal information only and should not be construed as legal advice. Today, we are here to talk about record clearing options available to Texans, specifically expunctions and non-disclosures, and the types of situations that Texans face that may make them eligible for these options. My name is Fallon Hamilton, and I'm a staff attorney with Lone Star Legal Aid. Lone Star Legal Aid is a nonprofit organization that assists clients with their civil legal needs and serves 76 counties in Texas. We do advocacy, legal representation, and community education to ensure equal access to justice. Myself, along with my coworker Mariah Gorham, are both attorneys with the Civil Matters and Criminal Justice Unit here at Lone Star. We assist people with their criminal convictions in a variety of ways. The areas we will be discussing today is record clearing through expunctions and non-disclosures. We are joined here today by our special guest, Sarah Mae Jennings with the Texas Fair Defense Project. Sarah Mae Jennings is a staff attorney in Austin. Previously, she has worked as a trial attorney at the Orleans Public Defender's Office in New Orleans, Louisiana. She began her work there as a fellow supported by Texas Law Gideon's Promise Fellowship. She was a pro bono scholar and led an expunction project and driver's license reclamation project as a law student. Thank you for joining us, Sarah and Mariah. How are y'all doing today?
Doing good, thank you.
Doing great. Excited to be here. Thank you for the introduction.
Wonderful. So we want to jump right in with the conversation. Can you tell us, Sarah, what exactly is the Texas Fair Defense Project and their mission and what all you all do?
Absolutely. So the Texas Fair Defense Project fights to end the criminalization of poverty in Texas. We do that through a variety of different programs. I'm currently the director of our pro bono program. So through the pro bono program, we have two arms. We have the driver's license, reclamation, Class C ticket help, as well as the criminal record clearing, the expunctions and non-disclosures. So through that program, we try to partner folks who are in need of services with pro bono attorneys, ideally in their own community, so that those attorneys are helping out their own neighbors with these issues.
Wonderful. And how are you doing, Mariah?
I'm doing well, thank you.
So kind of the topic today is something that Mariah and I have been working on pretty much exclusively. It's for the expunctions and record clearing non-disclosures, just different types of situations where people may have been faced with the criminal justice system. They may have got a conviction, they may have done a probation or been on some type of deferred adjudication. They were released, their case was closed, and it's kind of like, okay, so now what? A lot of misconceptions. People don't realize that that's not the end of the story. Whenever you have a conviction, it's still going to show up on your background. It's still going to prevent you from getting housing in certain places. It's going to be a barrier until you take the next steps to kind of resolve the situation. And I'll ask this question of you both. What's the typical situation that you're seeing clients coming in with our program at Lone Star and also with yours, Sarah?
I could start. So the Texas Fair Defense Project is a nonprofit organization. So we're helping folks who are under 200% of the federal poverty guidelines. And they're coming to us oftentimes either because they've tried on their own to get this criminal record clearing relief and were not successful, or because they could not afford the help of an attorney to figure out if they're even eligible for this type of relief because it is so complicated. So they come to us and they say, look, I've had these involvements with the criminal legal system. Are my records eligible? Can you help me? So it is important work that we do on the front end, just helping people understand what's eligible, what's not, and why, in addition to linking them up with the attorney to then help them seal or expunge any eligible records. Because that first piece is so confusing, the way that the laws are written, and none of it is done automatically.
What about you,
Mm.
Mariah?
Yeah, so it's pretty similar, Sarah. We represent people who are at or below the federal poverty guidelines. But typically, what I see when I speak with clients is that they're a bit confused. They think because they had a case dismissed or because they completed deferred adjudication and had their case discharged, that these matters are no longer going to appear on their criminal record. And I have to explain to them that that's not the case. And so from there, I go on the process of explaining them what record clearing options are available to Texans and what their options are.
Yeah, so a lot of people may not realize that this is a topic that may not directly affect them, but it's a high likelihood that it affects someone that they may know. Just some statistics. There is a vast population of Texans who have been arrested or have a record and would be eligible for record clearing. In 2018, the population in Texas was roughly 28.6 million. And at that time, about 15.4 million Texans had an arrest record. Arrest record is not the whole story of your criminal record. Many people are arrested and have had cases dismissed, or there are charges that were never brought against them, but that arrest is still on their record. And there's just a lot of confusion, as Mariah said, where people are really thinking like, well, they told me that I just go home, or they told me, hey, I don't have to worry about anything, or I did this deal and my attorney got it off, it was dismissed. That is not necessarily the case. Those records, even the arrest is still floating out there. What?
Ellen,
Oh,
could I
go
add
ahead.
another statistic? I love the
Uh-huh.
one that you just gave, and I have another one that I'd like to share. So as we mentioned, record clearing is not automatic in Texas. It's a petition-based system, meaning that the individual who's the subject of the records has to draft a legal petition and ask a court for relief.
Mm-hmm.
And so another statistic that I like to share with folks is that in a petition-based record clearing system, only 6.5% of eligible people are successfully getting their records cleared within 5 years of becoming eligible.
And
That's
just from,
so small.
yeah, from what I've seen, people don't even know that they have to initiate that step. It's like, okay, cool, you're telling people at the courthouse, all right, I'm gonna get you out, I'm your defense attorney, I'm doing all this work. And then it's like, okay, your case is dismissed, all right, go, bye, whatever.
Right.
It's not just going, the court is not sitting there saying, hey, let's go scroll through the list today and see whose records we could seal. You have to actually initiate the process. And that statistic that you shared is even more scary because it's like, okay, that's almost everybody. That's such a small percentage. And we're speaking of record clearing. Just to let everyone know that is listening, what are the record clearing options that are available to Texans? A lot of times we say words, but people may think they're one thing or they may not know the difference between the two. What are the two main ones and kind of what the distinction is?
Yes, absolutely. So in Texas, a person who is eligible for record clearing has two options, depending on their record. The first one is called an expunction. And so when a person is granted an expunction, that means that their arrest record is not going to be seen by anyone, not the government, not government agencies. And that's really ideal, but that is only for cases that were dismissed or follow under the statute. The other one is called a non-disclosure, and that's for people who have completed deferred adjudication or have like a one-time misdemeanor conviction on their record. And those cases can be sealed using a non-disclosure. And this allows most people to not be able to see it. However, the government agencies listed in the statute, they'll still be able to see those records. But overall, both of those options, if pursued, allow a person to be able to apply for a job, to be able to apply to rent a house or rent an apartment without those matters showing up.
Right. And what I hear a lot of is people using those terms interchangeably. An expunction is not going to occur if you have a charge. If you were found guilty in your trial, you're not going to be eligible for an expunction. If you did probation straight across the board, there maybe some instances, but more than likely that's not going to be the option that's going to work for you. Expunction, people usually use that word. I feel like the non-disclosure is probably less recognized because everybody calls it an expunction. I want to expunge this. I want to do this for an expunction. Who and what instances make someone eligible to get an expunction? And neither one of you can jump in with that response.
I can jump in here. So for expunctions, as Mariah said, if your case was dismissed, that would be eligible for an expunction. If it was dismissed because of pretrial diversion and intervention, that's another big one. That's immediately eligible for an expunction. If you were arrested and never formally charged in court, that's also expunction eligible if the statute of limitations has run. And we can circle back to that term. If you were acquitted at trial, so if you were found not guilty by the jury or judge at trial, you should be eligible for an expunction. If you were pardoned, which is very rare, I've never handled a pardon expunction, but that would be eligible. And a new provision under the law is if you had an unlawful carry of a weapon conviction, that may be eligible for an expunction.
Can you talk a little bit more about that one? That law may be something that people would be interested to know, just because we see a lot of people who want to get record clearing just because they want to be able to legally possess a firearm.
I'm actually not super well versed in restoring gun rights. I don't know, Mariah, if you have a bit more knowledge, because I get this question a lot and I'm like, I should know this, I should look this up, but I don't know as much about getting your gun rights back.
I believe so. It's my understanding that there are cases where a person was arrested for unlawfully possessing a gun, that when the new law went into effect, those cases were dismissed and those qualify for an expunction. It's my understanding that if a person got, say, deferred adjudication for unlawfully carrying a gun, they still would have to only pursue a non-disclosure at that point.
Yeah, I feel like we will probably be getting a lot of people wanting to know about the nuances. So I'll be doing a little bit more research into that one also. And just a segue, since we mentioned non-disclosures, can we kind of give everyone a lay person's explanation of what the non-disclosure is, what it does, and who is qualifying for that? And for me, I feel like I've seen more people eligible for non-disclosures than expunctions, but everybody still calls them expunctions regardless of the difference.
Yes, absolutely. Well, do you want to talk about it? You want me to?
I thought you did a good job explaining it the first go round, so happy to add some points, or if you want to take this, either way.
Let me just say this. So mainly it's for people who've completed deferred adjudication. That's mostly what I see. If a person has successfully completed the terms for either probation or paying back a fine or whatever was agreed upon with the prosecution in the initial case, and the judge has discharged that case, those people qualify after a waiting period. There are also cases where a person has like a misdemeanor final conviction. Usually it's like a one-off misdemeanor, and those can be sealed with the non-disclosure, excuse me. And again, those are just sealing records. So the government and listed agencies in the statute are still going to be able to see those.
I think those are my favorite kind to do, because I've run into so many people who were like, oh, well, I only did 1 day in jail, or I got in trouble. They told me if I just wait it out, they'll let me out tomorrow. And a lot of those people are doing that because they can't afford to miss work for 2-3 days. They don't know if they can afford an attorney to fight something. They're really kind of doing it because it's like a back up against the wall type of situation. And it's like, okay, either I'm gonna just sit here for a day is nothing, not realizing the consequences of that day. That 1 day in jail is still going to look like a conviction on your record. For that one, you can't do anything else. You can't have anything else on your record. It's like one of those situations where like the one-off college student who's gotten in trouble, or I've seen people just get in trouble for like the smallest things and they're thinking, okay, I'll just get out Tuesday, I'll just stay here and that's it. Like 1 day, how can this 1 day completely ruin my life? And then it's like, I've never been in trouble, I've never done anything, and it's still this one day. Those would be the ones who would be eligible to get that sealed. And of course, the judge is going to look at the circumstances surrounding it always. They're going to want to know what you plan to do with your life. A lot of times the judges will want to see that you've been trying to look for a job, or they'll want to see that you've been trying to further your education, or that you stayed out of trouble this whole time, because it's like a privilege kind of in their eyes to seal this for you, even though the criminal justice agencies still can see it. But for the lay people or just the general public, it's like, okay, no one else is going to see this. No one is going to know that something happened to me. Now, can you all explain kind of the process for both? When they come into our offices, what would someone expect, and what would that process look like as going through the motions of getting their record sealed or cleared or destroyed in an expunction?
Could I make a quick comment about a piece of what you just said before we
Of
go into the
course.
question? First, I just really appreciated the context that you gave for why people might have convictions as a public defender, especially, that it is so true for so many that it's not necessarily like, oh, I was dead to rights guilty of this crime. It could be the sort of situation that somebody is taking a plea just to get out of jail, get back home, what have you. But also you touched on, when judges are looking at the first time misdemeanor conviction non-disclosure, they're trying to decide if it's in the interest of justice to grant that non-disclosure. So that's a special part of non-disclosures that's different from expunctions. Expunctions, if you meet the statutory requirements, then the judge must grant the expunction. There's no discretion for the judge to say, not you as an individual, not this time. Versus most non-disclosures, there's one type that doesn't have this, but most of them have that interest of justice standard that the judge is going to evaluate whether or not it would be in the best interest of justice to grant this non-disclosure for you as an individual for this case. So I just think that's important for folks to be aware of, that might come up for non-disclosures.
And that's absolutely the key when it comes to the non-disclosures. They're looking if was the crime that you committed just so detrimental to society and the justice that not giving you this right is going to like tip the balance. So for my experience, I've seen more times than less times that the judge really is going to see that this person is trying to make a difference and like understand the totality of the circumstances. So thank you for pointing that out. And if y'all want to go through just kind of the process once you accept the case, once they come in and they're our client and we're going to do this case for you, what would it look like? What does that process look like for someone who may have never been to a legal aid office or maybe never had our services before?
Yes, so for Lone Star, how it looks, once we accept a case, I draft a petition because, as Sarah mentioned, Texas is a petition-based record clearing state, which means a person has to petition the judge for either an expunction or a non-disclosure. And then once those petitions are filed with the court will set a hearing date, typically for an expunction, especially here in Houston. Those hearings end up being waived as long as the DA, is unopposed. But for the non-disclosures, we just go to court with the client and we say, Judge, this person has moved on with their life. It is in the best interest of justice for them to no longer have this shadow of a crime that they committed, likely years ago, still hanging over their head. And then if the judge doesn't agrees, then an order is signed. And once that order is signed, all the agencies listed in the petition, whether it's for the expunction or non-disclosure, they start destroying records. So that way it can no longer be found.
What about with your office, Sarah? I think Sarah may be frozen. We'll give her a chance to jump back on. Are there ever any times when a person's charges would not qualify? Like what would be the client that we would not be able to provide assistance for?
Yes, so for non-disclosures in particularly, The courts are going to look at a person's criminal record as a whole. When it's an expunction, they look at the arrest. For a non-disclosure, there are other matters on a person's criminal record that can keep them from qualifying for a non-disclosure. For example, in the statutes, there is a list of offenses that if a person has ever committed, then they will never be able to qualify for a non-disclosure for any matter. And even if they completed the terms, completed deferred adjudication, probation, paid any fine. And that's often really hard to tell a client and to tell them, I'm sorry, because you had a family violence case, because you and your siblings got into a fight that happened 10 years ago. This matter that's more recent that you would otherwise qualify for is not going to be able to be non-disclosed. And that's a hard conversation to have.
Yeah, it really is. I think Sarah is back.
Sorry, guys. I don't
No
know what happened.
worries.
All of a sudden, everyone froze. Classic
Technology. Yes.
Yeah.
No worries.
Back.
The question was, can you walk us through what the process is like with your office for potential clients?
Yes. So we have an application available online. It's been shut down, but it'll reopen next week. And we also conduct intake through our main phone line. So you'll complete an application either online or over the phone with our legal assistant. And within 1 month, I, or hopefully our new record clearing attorney, will be in touch with you to talk through your eligibility for our criminal record clearing services. And then you'll either go on our pro bono case list to wait to get connected to an attorney, or a staff attorney may take your case depending on the situation. Once you're paired with an attorney, in my experience, it takes us about 6 months to get from the application for criminal record clearing services all the way to a final signed order of expunction or non-disclosure. These things just take time. There are waiting periods sort of locked into the code language that they set out the hearings at least 30 days from filing the petition. Additionally, once the order is granted, there are other waiting periods. I think it's within 60 days of a non-disclosure order being signed, it should go into effect. And then for an expunction, the agencies have up to 1 year to comply with the order. So usually I'm seeing the local agencies, especially, complying with the orders much quicker than a year, but under the law, they have up to 1 year to destroy the records that have been ordered to be expunged. So it's a long process. I like to flag that up front just so our expectations are sort of tempered. Because a lot of times people are coming to me, especially in the pandemic, and they're like, I need this yesterday. And it's like, I'm so sorry. It just is a slow moving process, but we are doing our best, as well as our pro bono attorneys, to get this done as quick as we can.
Yes, we have seen that problem the whole pandemic, and people, a lot of times when those layoffs happen right at the beginning, some people may have never had to do a background check for their job, or their circumstances changed. There were a lot of people faced with trying to find a job after the fact. Like, I've been here for 10 years and they never asked what was going on. I'm a great employee. Now I'm not considered the best candidate just because of my record. And I only have a couple of more questions to ask you all, but I kind of wanted to go with this one. I saw Mariah had it on her list of topics to discuss, but I find it interesting just because you were a public defender. What is the best way for attorneys like our colleagues in the defense bar who don't necessarily focus their practice on record clearing or assisting low-income Texans? What would be the best advice or things that we would tell them to kind of take into consideration so that these people aren't just kind of faced with a loss, deer in the headlight after their case has been dismissed?
Great question. I would say phone a friend. I am oftentimes in a position of phoning a friend who is an expert in another area of the law, especially if I have a client with potential immigration consequences. That's not my wheelhouse. I want to make sure I'm calling upon somebody who knows how that will interplay with criminal record clearing before I do anything on my case. So likewise, call any of us. I'm volunteering you guys too.
Yes.
If you're looking at plea negotiations and you're like, I think this might be bad for criminal record clearing in the future. Let me just double check. One big thing I would say is to look at the language of 411.074 in the Texas Government Code, because there are 4 big categories of offenses, including anything involving family violence, that if you are convicted of or placed on deferred adjudication for any of those 4 categories, you are forever barred from petitioning for a non-disclosure for anything before or after that had nothing to do with the family violence conviction. That person can then not get their 2006 theft deferred sealed, because there are these big categories that are an absolute bar to even requesting a non-disclosure. So if nothing else, start there. It's a short list, and it would behoove your clients if you were aware of the consequences of pleading to any of those things.
Yes, I completely agree. For me, I would tell them to explain that just because the case is over, it's not over. Like, maybe consider adding some record clearing to your practice if you're going to be handling these cases. Like, at least be knowledgeable of the consequences. Like these deferred adjudications, like, okay, I did everything I was supposed to. They signed off. My case has been dismissed or closed out. It's been disposed of. I'm good. No, just make sure that people fully understand what they're agreeing to. Be it, I gotta go here on every Saturday and clean up. Okay, I did that. Now, why am I not able to get a job still? Why is this still showing up? Just make sure that y'all are going over the terms. And this is even for people who may not want to even go to the same attorney after they've gotten it. Like, make sure that you're at least reading and asking for that explanation of what happens after the fact. Like, hey, when this is over, like, I get that y'all are saying that my case is going to be disposed of, but how does that affect me going forward? Like, that's so important. That's even a question you can ask your own attorney, like, what is going to happen after the fact? So that would be my biggest advice for both our colleagues on the defense bar and for people who are going to be relying on their counsel to get them the best deal or get them out of trouble. Just make sure that you know what happens after the fact, because that's the majority of people that we run into don't realize it. Even with the family violence distinction, I had someone just really be like, well, that's it. That's all I did. I spanked my cousin or something. And I'm like, I know, but regardless of what it was, they still deemed it family violence. They still did this. This is in the statute. So unfortunately, we can't help you. And it's a very sad conversation to have with people, especially when it's like, well, the kid was bad. They were doing it. They deserve, like, it's like gut wrenching. Do you all have any situations with clients that stand out that just kind of made you be like, oh my God, I really feel like I did a good thing today. I really feel like I helped someone out, and kind of speak broadly without giving any identifying information on what that situation was, just in case any of the listeners are finding themselves in that same predicament and not realizing that they potentially could be helped with record clearing.
Yes. So for me, I love that I've helped some clients after they have completed a pretrial intervention program. Sarah mentioned that a minute ago. So in Harris County, there are a number of pretrial intervention programs that a person can do if they have like one charge on their record. And this makes them eligible for an expunction a lot sooner than they typically would be after their case is dismissed. And then once we can get them that expunction, they can go on with their lives faster, essentially. So they had one, say, mistake on their records. They tried to steal something petty, and they went through the theft pretrial intervention program. Once they've completed it and their case is dismissed, they qualify for an expunction, and they can so much faster get on with their lives and have that mistake behind them.
Yeah, I love that situation also. What about you, Sarah?
Yeah, I'm grateful to be able to do this work every day. I feel like I tell my friends who are public defenders that I feel like criminal record clearing is like public defense without the fires.
Mm-hmm.
We have, the same clients who experience the same legal system now coming to us seeking services that we can either improve their situation or leave them as they came. So I love being able to provide this service to people. A few clients come to mind who have come back to me already and told me about new job opportunities that they've gotten because of our services. There was a gentleman who had one deferred adjudication from the 90s that was still holding him back. He would still get to the end of job interviews and then they wouldn't call him back because of his record. Like after interviews had gone really well. And then he sent me a note shortly after we sealed his record successfully, saying that he was reporting for orientation at his new job. And I'm just so happy for him. And also at the same time, so frustrated that he had to wait to find free legal services to seal this thing from so many years ago to put himself in a better position to re-enter the workforce. Like, I just wish that criminal records didn't have that scarlet letter effect on our clients the way that they do, but certainly relish the wins as they come, as we're trying to make progress in this area.
Yes, I get so discouraged when I'm reading the comments on like the Houston Chronicle or something where people like, well, they should have never done a crime. They don't deserve to not work with me, or I don't want someone who's concealing what they did from being my coworker. And that's so small-minded because bad things happen to good people. Like it's not a catch-all, I'm a criminal. And there are charges that do not qualify for record clearing. Like I really want people to realize that no, we're not sealing a kidnapping. We're not sealing a rapist. We're not sealing a domestic violence abuser. Like we're not sealing on some serious level type stuff. This is really bad things that have happened to good people who maybe have had their backs against the wall and had no choice but to steal or no choice but to do what they did, or they were young or other people influenced them. It's not always just terrible people out here trying to seek some redemption. That's not the case. It's probably more than likely with the statistics, somebody that's walking right by you that may have gotten in trouble and got caught up and you don't know the circumstances. So just don't be small-minded and realize that no, we're not out here trying to give people who've done tremendously bad things trump cards to get out of jail free. No, that's not what it is. It's making a difference and it's really changing some people's lives. That's my spiel. My soapbox is I will stand on it at the top and advocate for that change any day, every day, all day. You want to add to it, Sarah?
Yeah, I do. I want to jump in because the thing that sort of breaks my heart the most when I am telling clients no is most people who got one misdemeanor conviction probably don't just have the one.
Right.
It may have been a period of their lives. It may have been a string of bad things happening to good people, or even, the person just in the wrong place at the wrong time, what have you. But I get a lot of folks that have those old nonviolent misdemeanors that are eligible perhaps for the first time, but not for multiple. And I would love to see at the legislature more of a move towards recognizing that folks are worthy of redemption and clearing those records, not just for one, but maybe more. And it will still have to go across a judge's desk for that interest of justice standard that, maybe the judge doesn't sign off if it's 10, but let's talk about the folks who have 3, who have 4, so I just wanted to
or even in the amounts that are not even deemed legal, or the amounts of possession where a police officer wouldn't even bother you, or the DA wouldn't even waste time, but it's from 1985. So that wasn't the law then. Like those are the ones that really hurt my feelings when I'm like, okay, come on now. This is not like, ugh. just to close things out, you all have an event where we're partnering. Can you tell us about it? And also tell people how they can get in contact with both organizations to determine if they qualify for services.
Yes. We have a live application. It's bit.ly/Waco Clinic, no spaces, for a clinic that we're hosting in Waco on Saturday, April 23rd, 2022. The application's open now and will remain open until March 1st. And then we'll be getting in touch with folks to talk about eligibility. And if you are eligible, we'll have attorneys working for the month of March to draft up any eligible record clearing petitions. This clinic will have both record clearing and driver's license, Class C ticket help. So when you go online to the application, there's a lot of text there. There's 2 parts. Fill out whatever part applies to the services you're hoping to get. And we will let you know your eligibility after you apply. We'd rather you just go ahead and apply instead of calling us to ask questions, so that we can review the application and let you know that way. Did I miss
And
anything?
Lone Star is excited. I just wanted to say to be working with TFDP with this to assist the residents of Waco.
Yes, TFDP is also super excited for this clinic. I think it'll be great. And if there's any attorneys watching, feel free to get in touch with me. I will be hosting some trainings in advance of the clinic, or law students, and we'll be determining eligibility and drafting petitions in the month of March. So you can email me, sjennings, SJENNINGS @fairdefense.org. And I'd be happy to send you registration links for those trainings and volunteer opportunities.
Yes, and any upcoming outreaches, you can find out about them on our website. It's lonestarlegal.org. We have some things in the making also with record clearing for our unit, so we will be putting out more information once it becomes available. To call in to Lone Star Legal Aid, there's a toll-free number. It's 1-800-733-8394. Or you can also go on our website to apply and view available resources. If you want to know more about the Texas Fair Defense Project, you can call 512-637-5220 or go online to their website at fairdefense.org. I want to thank you both for your time and letting everybody know what services we're offering, and what a good job and hard work we're doing to kind of make a difference for people in Texas that are living at or below the federal poverty guideline, and all low income Texans, so we can kind of flip that balance and give them the tools they need to be better and feel like everybody is getting the same advantages out here in this world, especially in the legal system. Thank you so much for listening. Did you all have any final thoughts or comments you want to make before we let everyone go? And I'm not sure if there were any questions coming through on Facebook. If so, feel free to ask them and we'll go back and review it and try to answer them as quickly as we can. But otherwise, no questions at this time. Thank you, Sarah. Thank you, Mariah. And yeah, last thoughts, final questions.
Thank you, Fallon. Love
Yes,
the
thank
work you
you.
guys are doing. This was so much fun to be here with you guys this afternoon. I hope it was helpful to anyone out there watching.
Yes, thank you. Yeah, and that's all we have for you today. And catch us on Facebook. I believe the replay will be live once we get off. And feel free to give us a call if you have any questions about record clearing. Thank you.